So, there we go. Well, good afternoon, everybody, and welcome to the final Precognition to Proof session in what has been a tremendous series. And I'll come on later to thank everyone who has been involved in this series. I'm delighted to welcome Michael Way, who is going to speak to us about the mystery that is expenses. Michael's an advocate at the Scottish Bar. He's at Ampersand Advocates, and his principal areas of practice are public and administrative law, commercial disputes, and civil liberties and human rights. So he's going to speak to us today about expenses. My thanks go to Fraser White and Associates, who kindly sponsor the Zoom platform. And just as a little bit of housekeeping, as usual, if everyone could just bear in mind to keep themselves on mute and have my cameras off. And if you've got any questions, fire them in the chat box below. So without further ado, I'll pass over to Michael.
Thanks very much, Giorgio. So yeah, I have a slideshow, so I will try and make that work, but we will see. Ooh, there we go. Ooh, okay, all good. So, here we go. Precognition to proof expenses. So, who am I? Giorgio, give me a quick intro there. Yep, I'm an advocate at Ampersand, called to the bar in June 2019. So I've just had my 4th anniversary of calling. A tutor at Edinburgh University as well. Before that, I was a trainee at Brodie's, and I qualified very briefly there. I've got degrees from Edinburgh and KCL and Oxford. And as Giorgio says, I do a bit of commercial, a bit of public law, standing junior to the Scottish Government, do a bit of ad hoc ADing. The beauty of the Scottish Bar is you can do lots of different things. And yeah, I've just been appointed to the Scottish Minister's COVID inquiry team. So I think that'll be taking up a lot of my time for the foreseeable future. So what can we get out of today? Well, first of all, as perhaps some demystification, hopefully, about some of the theory, some of the practice, some of the language around expenses. I'm going to look at some sort of slightly more boutique things like additional charges, sanction for counsel, sanction for experts, and things like that. So hopefully should give you a bit of confidence if you have to deal with an expenses motion or you need to instruct somebody about expenses, how you can do that. So some of the key takeaways for today. Yeah, ultimately the court has a broad discretion in what to do with expenses, but it doesn't have a free choice. There's a basic rule for expenses, and that's that expenses follow success, but there are lots of exceptions to that. And so if you can come up with a good argument, you can potentially save your client a lot of money. There's a, so we'll talk about the additional charge motion, and that can be an important weapon, both tactically and again for recovering additional costs from the other side, which is always good. And finally, thinking about sanction for counsel, getting it in, well, remembering that it exists, doing it early, and if you don't do it early, what you need to do to sort it out. So what do we mean by expenses? Well, ultimately, expenses are all the charges that a party might incur in connection with legal process, court fees, solicitors and counsel, and other outlays that you might have. Expenses in terms of awards of expenses, those are an inherent power of the court, a discretionary power, but also a broad power. So we'll come and look at those three different aspects: inherent power, discretionary power, and broad power. Obviously, sort of bearing in mind that the actual expenses that your client is likely to incur are almost always going to differ from what is covered under an award of expenses. So obviously, can be a sensitive matter to explain that to your client, but something that has to be broached in almost all cases. In terms of the practicalities, in a lot of low value cases, the expenses will massively outstrip the actual value of the case, and even, to be honest, in some fairly high value cases. And so you do find a lot of litigation can end up being a fight about expenses and about how to divvy that up. So it is, although I guess there's an element where people kind of think about expenses as an afterthought. Obviously, they are an incidental matter as opposed to the sort of key thing that your clients are fighting about. But ultimately, it can be very important. And so factoring in expenses into your tactical approach is really vital in making sure that you obtain the best outcome for your clients. So thinking of those three aspects: inherent, discretionary, broad. So the first, it's an inherent power. So the court has the power at common law to award expenses. You do frequently see craves, conclusions, pleas in law directed to expenses. None of these are strictly necessary, but I guess there's no harm in putting them in, but they're not required, and certainly you can be granted expenses without having craved the expenses in your initial writ. Any party to an ordinary action can be found liable in expenses to any of the other parties in really any proportion that the court determines. So, it's a really sort of crucial point to get across to anyone who is, if you've got multiple potential clients or potential parties to an action, making clear their potential liability in expenses is, obviously vital. It's not competent to award expenses against somebody who's not a party to an action, unless there's two exceptions to that. The first is if they're so-called dominus litis, which means effectively a sort of somebody who's the actual litigant who's standing behind a sort of a kind of almost representative litigant. That's fairly uncommon, but it is also competent to award expenses directly against a solicitor acting for a party. I'm not going to go into that in any particular detail today, just for time-wise, but it is something to bear in mind that in circumstances where possibly the potential for recovery against the client is low, if there has been fairly bad conduct of the litigation by the solicitor, some sort of reprehensible conduct, then it is possible to seek expenses directly against the solicitor. So second aspect is that it's a discretionary power. So sometimes you hear people say, well, it's just simply a matter for your lordship's discretion. But what does this really mean? So it doesn't mean arbitrary. It doesn't mean just a free choice that the court can do whatever it wants. It has to apply well-known general rules. And if it's going to depart from them, it should have a good reason to do that. So I've got this quote from Lord President Cooper in the case of Howitt and Alexander and Sons. And I think the bits I've kind of highlighted there are the sort of important bits. So it's, an award of expenses according to our law is a matter for the exercise in each case of judicial discretion, fine, designed to achieve substantial justice and very rarely disturbed on appeal. So I think that's a really sort of key point to sort of bear in mind when you're thinking about how to approach. If you're thinking, well, can I argue for any of the expenses even though I've lost? Thinking, right, we're trying to achieve substantial justice. That's the underlying policy reason for awards of expenses. So that is something to sort of, I think, a good hook to sort of build your submissions around. Very rarely disturbed on appeal. There's various, both judicial dicta and any book that you care to read about expenses will make it very clear that the expenses appeals are highly frowned upon and very unlikely to succeed. So it's worth getting it right first time, because otherwise you could be stuck with that with not much way of getting out of it. And then the third aspect is a broad power. So the court is entitled to pronounce a wide range of orders. Obviously, the common ones, the first sort of, first one I've listed there, just a simple award of expenses without further specification. Just I award the expenses of process to the pursuer on the basis that they were successful. End. You can obviously have a finding of no expenses due to or by, and I'll come back to that again when we're talking about decoding some of the lingo, and then finding that the expenses should be in the cause. Again, I'll come back to that when we're talking about the lingo. I've also got a list there of a variety of different orders, and I'm not going to go through that line by line, because I think you can all have a read of it, and I guess the slides may be available afterwards. But that's a really handy sort of list, just to, I guess, remind yourself of the potential range of things that you can actually ask for, which is obviously just a lot more than just, I would like the expenses, please, because I want. So we talked a little bit about the general rule, or some people say the basic rule, and that's that expenses follow success. So the first quote there at the top is a quote from Maclaren on expenses. Now, if you want to find out about expenses, then Maclaren is pretty much your go-to starting point. It's effectively where any other texts have cribbed things from, basically, and it is obviously sort of judicially recognised as a sort of authoritative work on the topic in Scotland. And that sort of sums it up. Again, the sort of policy reason why anybody is entitled to expenses. So if any party is put to expense in vindicating his rights, he's entitled to recover it from the person by whom it was created, unless there's something in his own conduct that gives him the character of an improper litigant in insisting on things which his title does not warrant. So that was quoted by Lord President Cooper in the Howitt case, and he kind of goes on underneath that in the second quote there to expand on that, and says, the cost of litigation should fall on the party who's caused it. The general rule for applying this principle is that the costs follow the event, the ratio being that the rights of parties are taken to have been all along, such as the ultimate decree declares them to be, and that whoever has resisted the vindication of those rights, whether by action or by defense, is prima facie to blame. So you can see from that, it's ultimately the kind of takes the result, works backwards and suggests, well, you must have been right all along. This person has tried to stop you and has contradicted you, and therefore they have put you to expense in vindicating your rights, and therefore you should be able to reclaim that from them, which obviously all makes sense. You can, he has this sort of saying that the final text box there, generally, obviously, if you've had substantial success, tends to be the term that people use, you'd be entitled to expenses. Obviously, we'll talk about QOCs, qualified one-way cost shifting, in a wee minute, but that is obviously a big exception. You can be successful even where a defender has not actually resisted or opposed your say initial writ, petition, whatever, appeal, if there were good grounds for raising it. And obviously all of this raises the question of what does success mean in any particular case. So what's success? It's obviously a debatable concept, and there is scope to persuade the court about whether you have been successful, whether your opponent has been unsuccessful. You do have to have had some success normally to be entitled to any expenses. If you've had no success at all, probably going to be hard to persuade. The case that I've cited there, Fox against the Scottish ministers, is a case, a sort of planning case about a compulsory purchase order, where the petitioner or the appellants had tried to get a CPO quashed. The council and the Scottish ministers had basically agreed to give an undertaking that they wouldn't enforce it. But the court declined to quash it because they said that, notwithstanding that they had kind of achieved their aim in terms of it not being enforced against them, the application that they'd made for it to be quashed didn't actually meet the statutory test as far as the court was concerned. So despite the fact that they were, in practical terms, successful, the court declined to award them expenses on the basis that they had not achieved success in the actual application that they had made. But in general terms, success is measured in sort of practical terms. So if you have obtained decree, that is generally success, and it doesn't really matter, or it shouldn't really matter, whether you, so say you're a defender and you've taken a time bar point and a title to sue point and a substantive defense, blah, blah, blah. Even if only one of those is successful, say your time bar point's not successful and your title to sue point's not successful, but you do have a substantive defense which is successful and you achieve an absolvitor, you should certainly be arguing that you have been substantially successful, notwithstanding that those two other pleas have failed. So there is sometimes a sort of understandable in cases where there's arguably divided success, as in somebody's raised the case on multiple bases, five of which have failed, but one of which has been successful. Then there is a tendency to try and argue, well, it was divided success. I only lost a little bit. I won most of the points. Certainly, the sort of core text tends to suggest that that is not really the right approach. You're not meant to be adding up, oh, I won this point at debate, even though we lost the thing, so therefore I should win overall. But having said that, if a winning party causes unnecessary expense through pursuing a line of argument which is ultimately unsuccessful, then that could provide a basis for suggesting that there should be some modification of expenses. The final point there, something that a lot of people maybe haven't encountered, but where a party abandons, they can still be entitled to the expenses. Now, generally, if you abandon in terms of the court rules in the sheriff court, then you have to, as a condition of abandoning, pay expenses. Certainly, if you want to obtain absolvitor, or if you want to dismissal, so that you could re-raise. But if you abandon at common law, then you can abandon on any terms that you like, and you can effectively ask the question of the court. And this is, I've had situations where people have obtained interim interdict to stop them being removed from a house. They've subsequently obtained alternative accommodation and then have sought to abandon the case on the basis that they no longer live there, and therefore they no longer need the interdict to stop them being removed. Now, in those cases, we effectively argued that I was for the people who were trying to do the evicting, and we argued, well, you substantively had lost your prima facie case because it was hinging on another sort of test case, and you lost the test case, and therefore you didn't have a basis for interdict. But in a few of those motions, they were actually successful in obtaining expenses. Other ones, the court held there was no expenses due to or by either party. So it's even if you abandon the case, it can still be worth asking the question about expenses. So obviously, if there's a general rule, it means there are exceptions and ways you can depart from that. The first one, again, I'm not going to go through this in any great detail, but qualified one-way cost shifting. It applies in personal injury cases in Scotland at the moment, and putting it at its sort of highest zoomed out view, it means that basically you can't get expenses against the pursuer unless various grounds obtain, which are essentially that there have been some sort of fraudulent actings on behalf of the pursuer. They've acted in a manifestly unreasonable manner, or the way they've conducted the litigation is such that it can be viewed as an abusive process. So I've put down a couple of cases that are relevant there. The case of Gilchrist against Chief Constable and Lennox against Iceland Foods. So these are both fairly recent cases from this year. And the tenor of both of them is ultimately that it's going to be a fairly hard battle for defenders to get expenses where the qualified one-way cost shifting applies. The court isn't going to lightly find that somebody has conducted an abusive process or they've acted manifestly unreasonably unless there's something very clear and it's effectively a sort of a claim that is kicked out and on the basis that is found to be fraudulent in some sort of way. But it could be that these cases discourage defenders from running the argument for a little bit, but maybe we'll see another case where they are successful and able to get some guidance about what would be successful. Tenders are obviously a big way that you can kind of reverse the expenses burden. Obviously, I know a lot of people, I'm sure, have experience with tenders as but just a very kind of quick overview. Obviously, if you are a defender and you put in a tender where you offer to settle the case for a particular amount, inclusive expenses, if the other party doesn't accept that and then goes to proof and obtains a lower amount than you were offering, then you're entitled to claim the expenses from the date of the tender. So that can be a really, really effective way of reversing the risk burden and putting a lot more risk on a pursuer to settle at an earlier date rather than gambling on beating a tender, which if you pitch the tender at the right level can really, really ratchet up pressure and can be really effective. Pursuer's offers, slightly different, but the effect of a pursuer's offer, various things, but one of them is that if you offer to settle on a particular level, you then obtain a higher reward from the court, then you're able to obtain a sort of bonus charge, or a bonus sort of decree amount, which is calculated by reference to the amount of expenses, half the expenses of processes taxed. So again, can be not quite an exception to the rule, but it's a sort of an interesting wrinkle on expenses motions that you will possibly have to deal with when you're in practice. Some of the grounds to modify an award I've sort of put down there. These are the sort of key ones. Ultimately, if there's been some sort of conduct of the litigation that has been blameworthy, then traditionally marking that blameworthy conduct in expenses is a way that you can the court is able to sort of show its disapproval. It's also a good, I think, in situations where there's a sort of threat of decree on the basis that you've defaulted in some way, you failed to lodge something, you failed to attend something, rather than kicking your case out, which is possibly a bit extreme. You know, the court can mark their displeasure in an award of expenses. Another ground to modify an award is maybe pre-action behavior was unreasonable. So, for example, raising an action without an action for payment without making a proper demand, raising interdict proceedings without giving the other side an opportunity to given undertaking that they might reasonably have given. So those things again can weigh in the balance. And as I was saying, improper or wasteful procedure. So obviously classic ones are bailing out of a debate the night before. Your client's going to eat the expenses. If you undertake a line of questioning which extends a proof extra days, which is ultimately ruled to be irrelevant, or in some way the evidence is discarded, again, could be a ground for the other side, notwithstanding that you might win, to say, well, look, this was wasted procedure, it was not necessary, and therefore those expenses should be either on you or our expenses should be modified to reflect that. And ultimately, successful parties can be found wholly liable in the expenses in exceptional circumstances. So again, just kind of bearing these things in mind, again, unusual, but not impossible. So yeah, decoding some expenses terminology, hopefully a little bit of demystification. And again, hopefully, if these things are all very obvious to you, then that's brilliant. I regularly, when I come to the sheriff court, certainly you get people going, does the expenses be in the cause, or are they, which one's that one again? So here we go. In the cause just means into a general bucket, award to the eventual winner. That's the easiest way I always think to think about it. If you need an authoritative judicial pronouncement on it, then you can look at Lord President Dunedin in the case of Glasgow and South West Railway against the Eyre Magistrates, where there seemed to be some debate about what it meant in 1911. And in classic judicial fashion, he said, well, of course, I don't think there's any real doubt. However, if there is any doubt, here's what it means. So expenses to go as a matter of right to the party who in the cause is eventually successful and who gets a general finding of expenses in his favor at the end. So if the sheriff or judge says, well, I'll just put these expenses in the cause, that means they're going into a bucket to effectively be won at the end by whoever wins. The expenses being reserved means that they're going to leave the question for another day. It preserves your right to be heard on expenses. And a really good tip is, if you're doing written submissions, just put a line in that says the pursuer invites the court to reserve the question of expenses. And you'll sometimes see when you're reading judgment, it will say at the end, I heard a debate over 2 days, Mr. Blah, Mr. Blah, and Mrs. Blah appeared, blah, 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 blah. And then at the end, just, I found the defender, liable, blah, blah, blah. I reserved all question of expenses. And that just means once the judgment is issued or once the decision is made, it means that you can then have a further hearing where you can argue about expenses, or you can agree the expenses with the other side and not bother having an motion. So that's another way to do it. Obviously, you don't need to have a judicial pronouncement on it. It's something that obviously you can agree between the parties, and that is obviously normally the most cost-effective way to do it. None due to or by, I think it's one of those phrases that people kind of, I guess, bandy around, maybe almost sounds like one word, like none due to or by. So it is all those words, none due to or by, and just means no award of expenses is made to either party. So each party just deals with their own costs. Another one in the other side of the slide there, I sort of say term is used when parties agree a drop hand settlement. Again, that's another bit of technical jargon, which just means that basically each party agrees that the case is just dropped and they each walk away and deal with their own expenses. Again, can be a good way to, I guess, crystallize a risk or crystallize a loss in some ways in a very sort of specific way. You can just say, look, I'll pay, you're wanting £10,000 and obviously you'll claim the expenses if you win. I'll give you £8,000 and we both just walk away right now. And that means you're saving additional money in not obviously having to pay their expenses. You're saving a bit of money against the eventual decree amount. And ultimately, you know exactly what you're going to pay, and you have to pay your own lawyers, but you're always going to have to pay your own lawyers anyway. Another bit of jargon that you'll often see in interlocutors is remits to the auditor to tax and report. Effectively, this kind of comes because there's kind of two stages, I guess, to an award of expenses. The court determines liability for expenses, as it says, the pursuer won, they're entitled to the expenses of the cause as taxed. And then there's a secondary stage where the auditor has taxed the account that's been submitted to them. Taxing, as I say over there, basically it's just checking that the charges are allowable, i.e. reasonable for conducting the proceedings in a proper manner. The auditor then produces a report, and parties can make objections to things that are either allowed or disallowed in the auditor's report. And so all that means when you see that there is I've made a finding that the pursuer is entitled to the expenses and is now allowed to submit a report of their expenses and account of expenses to the auditor to determine whether it's fair and reasonable. Again, the amount of times you actually have to go through a taxation in practice really varies. Quite often parties will be content to just simply agree a figure, to say, look, our expenses are X, are you willing to pay Y amount? Often people just say, yeah, that seems reasonable. I just move on. But if people, certainly where there's a sort of fight to the death, it often required, or parties are just completely intransigent in different ways, then you have to go to the auditor. Final one, except insofar as otherwise dealt with. That is just a handy phrase to remember. It should, like, the court should sort of say it of its own accord. But what it means is if you're making a general finding of expenses, i.e. you're entitled to all the expenses in the cause, just saying except insofar as otherwise dealt with just makes it clear that there may have, if there were any stages during the procedure where the expenses liability was already determined. So say, for example, there was an opposed motion hearing that the defender won, but ultimately the pursuer won overall, then it would just make it very clear that the general award of expenses leaves out this the opposed motion hearing, for example. So again, the court should put that in probably themselves, but if you can put it in yourself in your motion, in your written submissions on expenses and your oral submissions, then it just kind of shows that you are alive to those kind of issues. And I think it kind of is good practice. So when to move for expenses obviously depends on the circumstances. If you're moving for a final interlocutor, so one that's going to deal with the entire subject matter of the cause, then you have to move for expenses or ask that they're reserved. If you don't move the expenses, or at least ask for them to be reserved, then there is a chance that the court could just simply not put anything in the interlocutor about expenses. And that is generally read as meaning that no expenses are awarded to either party. And once a final interlocutor like that has been issued, the court's powers are finished. They're functus, as they say, and therefore it can be quite hard to deal with that other than appealing it or trying to get the court to sort of treat it as a sort of slip of the pen or a mistake or something. So just a single line in your written submissions at the end of a proof or your oral submissions or anything just says, ask the court to reserve the matter of expenses, and you're golden. If you're in an interlocutory hearing, like an opposed motion or something, often the successful party will just ask for the expenses to be dealt with then and there, and just do that at the bar or on WebEx nowadays, probably. If you don't move for them, then quite likely they'll just go into the cause, and there is potentially a chance that they could end up being lost if you lose the case overall. So it's I would say if you're in an opposed motion hearing or something like that, where the expenses can be dealt with very easily, then just move for them straight away. How do you move for them? Again, if you're in your written submissions, just something, just a line that says, if successful, pursuer seeks expense of the motion or the cause or whatever, except as far as I've already dealt with, or at the bar, just move the expenses, my lord. Nothing more fancy than that is required. I think it's one of those things where it can be slightly nerve-wracking sometimes, particularly if you've done a motion and then you find out if you've won and you win, and just remembering move for expenses, and also having discussed with the person who's instructing you, your client, whoever, what you want to do about expenses, what their attitude to expenses is. Would you like me to move for them if we win? Would you like me just to leave them in the cause? Just thinking about that in advance will save you a lot of stress, because you'll know what you're doing at the end, and so you'll have a note to yourself: if successful, move for expenses. Or think about, if we lose, what are we going to do? Are we going to oppose expenses? Often it's if you've lost a motion, quite obviously, maybe not really worth opposing the general rule. It can, perhaps certainly I find in the court session, there's generally a collegiate aspect to that, where generally people would just say, well, I've lost, so there we go. I guess the expenses will go against me. No opposition, my lord. And that's a way, I think, to, again, dealing with it in a pragmatic manner probably engenders a bit of good faith from the court and from your fellow opponents, who may well be your colleagues later. So a final sort of point on this, again, another thing to remember, another kind of potential wrinkle is, the various bases of taxation and the different scales that you can ask for. So again, most people just say, I just move for the expenses, my lord. If you move for the expenses, that's going to be on what's called a party-party basis. That's the default. But ultimately, a party-party basis means that realistically, your client is probably only going to be able to recover about 50%, maybe 60%, maybe 40%, depending on how much the lawyers are charging of their actual expenditure. So it, again, obviously something you need to explain to the client at an early stage, but it's that is the sort of ordinary basis. There is another basis, or two other potential bases, and that's the agent-client basis. Now, the agent-client basis, you've got two different varieties of that. First is client paying, and agent-client paying has to be specifically moved for, and it will always be highly contentious. If you're going to make a motion for agent and client paying expenses, you really have to intimate that in advance. There's no way it's going to be dealt with at an oral here, just at the end, popping up and saying, "Oh, move the expense on an agent and client basis, my lord." That's not really cricket. So if you're going to do that, say, look, reserve the matter of expenses. There'll be a motion in due course where we'd be seeking it on this basis, but you really had to be very clear about why you're doing that, what the grounds are. The case of McKee that I put there, Lord Hodge sort of sums up the principles very well. So that's your starting point there. But really, it's a sanction for incompetent, unreasonable, or reprehensible conduct in the litigation. So it's got to be something really quite bad, and something really that reflects on the client rather than the solicitor themselves. Agent-client third-party paying is even more specific. You need to specifically ask for that. If you just say agent-client, then it's normally agent-client paying. That is, described as recovery of expenses that would be incurred by a prudent man of business without special instructions from the client, in the knowledge that the account would be taxed. So it's normally seen as being less than agent-client paying, but much more than party-party basis. Again, will be highly contentious. I've never come across anybody actually asking for that in practice so far. It's always been agent-client paying. But yeah, those motions, again, as we're going to talk about the additional charge in a minute, can be a sort of potential negotiating tactic as well. Quite often people put these motions in not really wanting to run them, but wanting to try and force you into agreeing expenses in some other way. So the additional charge, that is a type of motion that can be made by a successful party. Normally people call it the additional fee, asking for additional fee or asking for an uplift in fees. The technical term is additional charge. That's what it says in the Accident Taxation and Judicial Expenses Rules 2019, which people still like to call the new rules. They've been out for 4 years now, but they're still the new rules. Yeah, so I've just kind of put in the sort of basis that you can, I guess the technical sort of technical things you need to do to make a motion. So you're allowed to ask for one of these additional charge motions. A sheriff has to determine it themselves. In the court of session, the auditor can determine it if the court says they should, but also the court can deal with it themselves. The court or the auditor must grant the application where it's satisfied an increase is justified to reflect the responsibility undertaken by the solicitor in the conduct of the proceedings. So it's one thing, obviously, I've only dealt with this in the context of being instructed by a solicitor, which obviously does make it slightly more difficult because the basis of the motion is that there was something specifically undertaken by the solicitor rather than by counsel. So it's really, I think, particularly applicable where something has been undertaken by a solicitor that they might have been entitled to. There was, sufficiently complex, novel, interesting, difficult, etc., that it would be entitled to instruct counsel, but they've done it themselves. That is, a sort of good starting point for thinking, well, we're in the sort of in the ballpark of an additional charge motion. If granted, say the court or the auditor has to specify the percentage increase in the charges to be allowed at a taxation. So practical tips, relevant factors. So there's A to G there. Again, not going to read them out, but those are the factors that the court has to have regard to when determining whether the motion is well-founded. You have to specify in your motion the amount of uplift that you want. Well, I mean, you don't have to, but you should. There is no maximum. I think in the old Sheriff Court rules, there used to be a maximum amount, I think 50%. That has actually gone. And in this case of McLean against Greater Glasgow Clyde NHS Board, uplift was granted at 167%. So you can ask for a lot. Sometimes people look at each sort of different head and say each one's worth 10%. And so if they've got all of them, you get 10% each. Sometimes people say, oh, 10% for this one because it was really applicable and 5% for another one. There's a lot of ways to approach it, but those are some ways that people do it. Or you can do a kind of cumulo basis where you say this one applies, and therefore it should be X amount. Motions have to give sufficiently clear and detailed written reasons for the additional charge sought with reference to the relevant factors. Again, the way I've seen it done, I think this is quite a good way to do it, is just get out when you're setting out your submission, just say, here are the relevant factors. A, the complexity of the proceedings and the number of difficulty and novelty of questions raised, and then have a narrative underneath that explaining why it is complex, why it was novel, why it was difficult, blah, blah, blah. And then B, skill, time and labor and specialist knowledge of the solicitor, and explain why. So it just makes it very clear which factor you're relying on and why. Generally, I say kind of reserved for cases that are somehow out of the ordinary or exceptional. There's no hard and fast rule to that. I think that's what they're meant to be for, but you often see them in cases where maybe they're not particularly out of the ordinary or exceptional. But as I say at the bottom, if you don't ask, then you don't get. It can, as I say, along with agent, client paying, sometimes you see them come in together, somebody asking for agent, client paying, putting an additional fee in as well. And then it really focuses the mind on there's a fairly high amount of risk that we could end up with a very, very hefty expenses bill here. And so perhaps if we agree to something, perhaps agree if they ask for 50%, they ask for 100%, and they might agree to 20% or 10%, that mitigates that risk. Now, ultimately, obviously, the court might refuse to give anything, and so you're giving away 10% potentially, but that can be a worthwhile trade-off to mitigate the risks. So the final section is about sanction for counsel in the sheriff court. Obviously, you can instruct counsel for anything that you want, but their fees are only recoverable in the expenses if you have proper sanction in place. The test is section 108 of the Court Reform Scotland Act. And so the court must sanction counsel if it considers in all the circumstances it's reasonable to do so. They've got to have regard to these factors. The key ones are the difficulty or complexity of the proceedings, the importance or value of the claim, and the desirability of ensuring that no party gains an unfair advantage. So basically a sort of equality of arms argument. However, the court can have regard to any other matters that it considers appropriate. So as a basic rule, if it's an important, difficult, or complex case, it should be reasonable to instruct counsel. Again, sheriffs take, I found, sort of differing views towards this. I think I've only had one case where sanction has been refused. Certainly, I think where sheriffs used to be members of faculty, they tend to be fairly keen to grant sanction, perhaps less so if not. But here are some practical tips. Look at the new rules, as I'm not allowed to call them, the Taxation of Judicial Expenses Rules 2019. One of the key things is don't delay, because technically speaking, no fees are allowed unless the proceedings have been sanctioned, and sanction is granted as a default rule prospectively, so only from the date of the interlocutor. So we'll come back to what happens if you've done work before that in a second, but that's the basic rule, is that once sanction's in place, it covers whatever happens after that, but not before it. You have to seek sanction for one of the following: either the proceedings, any part of the proceedings, particular work involved in the conduct of the proceedings, or a combination of A, B, and C. Most people write, I seek sanction for the cause. That is fine, but why not just use the term that's in the rules if you want to be precise? I would say sanction for the proceedings. If, as is almost always the case, counsel has undertaken some work before sanction has been granted, what do you need to do? So what you need to do is you need to, when you put in your motion seeking sanction for the proceedings going forward, presuming you want counsel to be involved going forward, you ask for that to be granted, but you also ask for the particular work involved in the conduct of the proceedings, and you need to specify what that has been. So you need to say drafting the initial writ, consultation with client, adjusting pleadings, attendance at options hearing, if you're making it the options hearing, for example. That way you cover your bases. You will get sanctioned for all those things retrospectively if you show cause for not having applied sooner. What is sufficient cause is obviously a debatable concept. If you lodge a record late, or you've not lodged a record, you need to show cause why it should be received late. Almost always you just say, I forgot, my lord, sorry. And then strangely, you've shown cause. However, I've found that sheriffs take a slightly more stringent view of what cause you need to show for this. But one thing you can do is make a sort of pragmatic argument. If you say that counsel's come in at the adjustment phase, you're about to have an options hearing, making the motion the options hearing and just saying, well, look, this was the next convenient time that I could bring this to the court's attention without having to have a separate hearing. It was the most efficient way to do it. And that is therefore cause for not having applied sooner. And this is what has been done, and this is what we're seeking going forward. And normally I've found that sheriffs tend to accept that. One point to remember is that if senior is required, then you do need specific sanction covering senior counsel. If you just get sanctioned for the cause, then that will only cover junior counsel rates. So if you employ senior, you've only got sanction for junior, then you'll only be able to recover their fees to the extent that they would be recoverable as a junior. So if you've got senior counsel charging you £10,000 a day, then you will be, or your client will be certainly sorely out of pocket if they're trying to recover those expenses at the end of the day. However, again, final point, you can always instruct counsel, but sanction is about recoverability of fees. So some final takeaways. You've got to hopefully now understand the broad nature of the discretion, and hopefully you now have some tips as how to argue entitlement, sort of what are the relevant factors about modification and scale if you have to. Hopefully you now have some idea about the grounds for an additional charge motion, and that you can move for one if you think you've got a good argument. And the final point is to instruct and get sanctioned for counsel early. Otherwise, there is a bit of work you have to do. So that is everything that I had to say. I will stop sharing the screen, and I will come back if anybody has. We've got about 7, 8 minutes, I guess, for some questions, if people have some questions.
Michael, thank you very much. I think there's a question that's just come into the chat box.
Yeah, can we have a copy of the PowerPoint? I'm sure I can ping it on to sign that, and they can make it available in some way or form.
I have a brief question, if that's okay. I think in an earlier session, we heard about the importance, particularly I think in commercial actions, of issuing pre-action correspondence. Of course, the practice note essentially demands that you do that. I wonder, do you have any, I suppose, lived experience or views on instances where those particular directions are not complied with, and the consequences on expenses, perhaps further down the line? Yeah,
well, no, I mean, I don't, on the basis that I think certainly, but generally, obviously, sort of the people who are operating in the commercial court and the court session, generally sort of big firms who are quite experienced doing this, and they all know that you have to do it. I guess the situation might sort of come if it's maybe a party litigant or something, but certainly, yeah, a failure to follow a pre-action protocol is a sort of classic potential ground for saying, well, even you've been successful, there was a way that this could have been avoided. You've basically improperly used the court procedure in a way that you shouldn't have done, and that can be clearly marked in an award of expenses against you, or modification of any expenses you get. So I think that's a really good kind of example of something where you can be like, okay, this is, because that's the thing. It's one of those things where if you turn up to court and somebody's not lodged something, or somebody's, they lodged that thing late, my lord, and you're like, what am I going to do? We're at proof now. Should I just dismiss the case today, or should we just do the proof? Much easier for the court to say, look, well, that's a matter we can deal with in expenses, Mr. Way. And it's a way of even, rather than raising yourself and maybe making yourself look a bit sort of silly, just going like, oh, my lord, maybe you should kick out their case today because they didn't lodge the record, within 2 days. They lodged it in 3 days. Just saying, Lord, I do note that the record was lodged late, perhaps a matter that I can return to in expenses in due course, and just kind of gives a shot across the bow, makes it clear to the court that you know that this has happened, you're bringing it up, but you're not taking it sort of over the top.
Perfect, thank you. Got a question from Christy. She says, Michael, can you possibly explain agent, client, third party paying again? Yeah. And what would give rise to this?
So agent, client, third party paying is basically another way. It's another scale of taxation. It's meant to be based on the kind of expenses that would be incurred, rather than just by the litigant or just a litigant themselves. In England, they tend to be called, you might hear like in the press or something, indemnity costs for agent, client paying, which basically means full recovery of whatever you've actually spent, whether that's, instructing Brody's and the Dean of Faculty, at, absolute top whack rates or whatever, then, then that's kind of what that is designed to sort of cover. Agent client third party paying is a little bit less, as in a prudent man of business, as the old sort of saying goes. Probably not, probably something you can say rather than that. And I'm a prudent business person these days. But yeah, they might not undertake every expense that just an ordinary litigant might. So it's perhaps a slightly less extreme version. I don't know. As I say, I've never actually come across anybody asking for it. Normally, if somebody is asking for agent and client, then it's a fairly nuclear option, and they're only doing it because something has gone really badly wrong. But it's perhaps a slightly more nuanced way of making a fairly bombshell motion. But as I say, I've not actually ever cut. It's one of these things that I've read about in books and I've heard about. I've never actually seen anybody do it, but maybe we should try.
Thank you very much. Well, thank you, Michael. I'm very grateful for you having given up your time to share your experience and expertise. Thank you to all of our speakers who have, throughout the last, I think, 10 weeks, taken the time to prepare and share with us their expertise and experience. We are very grateful, so thank you. I've got a few further thank yous, particularly to my colleagues, Patricia Taylor, Brian Ellis-Scott and Sophie Campbell, who they've each played a crucial role in organising this series. It's been a really popular series, so thank you very much to all of our attendees as well. I saw on the call over 50 today, and that's been a running theme throughout, so it's been a good success. This is the penultimate CPD session that SILA are running this term. We're about to break up for a summer break, so we should be back in and around September. So all I've got to do is say thank you to everyone, and hope you enjoy your summer. Thanks very much.
Thanks, guys.
Cheers.
Thanks for coming as well.